first aggressor. That's what he goes. The James state of mind. He hollered, let me run. He jumped on me before. Then he the one come through the window. Woof. You see what I'm trying to show you, Judge? He was the first aggressor. I didn't shoot him. I didn't even shoot until he come through that window and grabbed him. And he said, I shoot. You ever not heard that? Don't let him be like that down here. I'm already thinking about you to jump on me before, bro. That's why I got this case. And I got some more cases to. Let's go. I got another case for you, U.S. versus, I can't say it, but I spell it for you. U.S. versus S-A-E-N-Z. 179 Federal 3rd, 686, 1999. This is the United States Court of Appeal, 9th Circuit. This federal court. And it says this, provocation, justification of self-defense. Evidence of defendant, knowledge of victim prior acts of violence was admissible to show the defendant's state of mind for purpose of his claim of self-defense and prosecution for assault with a dangerous weapon with intent to do bodily harm. Federal Rule Evidence 404B, 28 U.S.C.A. And it also says self-defense. One element of self-defense is the defendant's reasonable belief that his use of force was necessary. And it also what it says, rules that prohibit evidence other than actual establishment. That's Federal Rule Evidence 404B. Even the Federal Rule of Evidence, the Georgia Rule of Evidence was that they adopted Federal. 404B also says, shows, and I can show this. And it says, improper exclusion of defendant knowledge of the victim prior acts to show the defendant's state of mind for purpose of his self-defense claim and prosecution for assault with a dangerous weapon with intent to do bodily harm was not harmless error, because error prevented the defendant from supporting his claim of self-defense. Therefore, the language comes from because I've read these cases, and they go right hand in hand with my situation. The circumstances might be different, but the principle is the same. My defense is justification, self-defense. That's what I'm trying to show for him to defend myself against this guy. And the prior bad acts in this jail, it was still it. We had the Georgia Supreme Court and the federal court and the 404B corroborating what I'm saying,
Is there anything else? Because Mr. Malton has the last say. It's his motion, and I'll tell you that after he finishes, that's going to be all I'll hear on this.
Okay, let me make sure. Okay, I'd like you to look at Milton versus State 245, Georgia, 1980. This is a Georgia Supreme Court case. It says, it says, in murder trial, deceased general reputation or character for violence is admissible only when there have been a prima facie showing by the defendant that deceased was assaulted, that deceased assaulted the defendant, and that the defendant was honestly trying to defend himself. He had assaulted me before at Harrison Park County Jail. And when he was screaming like he was yelling, let me get away from it. I was honestly trying to defend myself. He the one come through the one at me. He even told the judge, I didn't see a gun. The gun was stuck down in here. You couldn't see it. The shirt was over. I'm just trying to get away from it. I said, I was the first, he was the first aggressor. One Jay. Jay already got the state of mind. You're going to hurt him again. So, this says, previous House of Acts or conduct of victim. Rule requires proof by defendant. Proof of a prima facie cause a case of present assault by deceased on the defendant applies a homicide case in which the defendant seeks to prove prior specific act or assault by the deceased upon the defendant to illustrate his contention that he reasonably believed he had to use deadly force to defend himself. Right? Hand in hand with us. I got to prove it. I just can't say it. And the jury got to hear the evidence to see why. Maybe we see why the man doing it. We might not like it, but we can see his point of view. We see Jamie just, it wasn't his intent that day. It made no matter his personal. Manner of proving character of habits. The murder trial, general reputation of character of deceased or violence cannot be established by proof or prior specific act of violence. This is known circumstances. You can't prove it. It's not relevant unless you can show, hey, he was the first aggressor, and to go to the defendant's state of mind. They got him labeled as a victim here. It says specific treatment difference between deceased and accused may be introduced against the defendant to illustrate his motive for murder. They said defendant here, but we can use the principle. I was defending myself. That's what my defense is. I was defending myself. Justification. In this case, it might have been the defendant, but we still can use that to bring it in. Hey, this is why this guy was defending himself. Previous forms of evil felony. In case of doubt as to whether or not evidence or prior difference between victim and accused should be omitted in the homicide prosecution, evidence should be omitted, and its credibility and weight should be decided by the jury. The jury got to take the evidence in, not the prosecutor, not the defendant. It says, that this is the Supreme Court of Georgia, it says the credibility and weight should be decided by the jury. If we were doing a bench trial, y'all, you will be the one who decides that. But we're not doing a bench trial here, we're doing a jury trial. So, hey, if the jury get a testimony, judge, they the one got to get the credibility to it, not the prosecutor. Not even the judge, because the judge is not on the bench trial. Okay. It says previous hostile act or conduct of victim. Testimony and witness testimony. Testimony and witnesses testimony, which would have been used to prove specific instances in which the deceased had used firearm or other weapon or object to assault the defendant. Not to prove general reputation. I'm not here to prove his general reputation. I'm here to prove what happened between him and I. If I'm going into his character, yeah, I can see it. I'm not here for no general reputation. I'm here to show that he was the first aggressor, and I'm here to show the defendant's neighborhood mind at the time of the police incident. It says not to prove general reputation of deceased for violence, but to illustrate to the jury the basis for the contention that he reasonably believed that deceased was reaching for a pistol. I'm not here to show, hey, his general reputation. When he said, I shoot, I had reason to believe, hey, this man didn't kill me. It was reasonable. You heard it, you saw the video, everybody saw it. Hey, don't let me believe like they got me. I didn't wait 4 years later to come here and say to the judge, I said the same like I turned myself in. My story's not been the same for 4 years. I've been telling it to you. You've been reading emotion. I can't change it. I wish I could. But that's...
Anything else, Mr. Ball?
Yes, Judge. First of all, of course, we didn't address anything about the 97 case.
Okay.
I would stand on my position in that regard, that he commented that should not be retried in this case.
What time is it?
guilt innocence phase, even in the guilty phase, certainly not admissible in the guilt innocence phase. Anything you're talking about that address the particular motion in regard to matters that I talked about as far as any conduct that's occurred in regard to the preacher's wife that you talked about. Being basically trying to prove that that happened was very much. And so none of that relates to anything whatsoever. In citation, of course, that were prior to the Evan Judge Georgia, report 24404 A that addresses that, as you know, what he was talking about there. And of course, evidence of the person's character and training character should not be admissible in the person proving action in component that are read on a particular case except for, as it says, A2, subject to limitations imposed by Code Section 24.4.12, evidence of the person. Evidence of a perfect character trait of alleged victim of crime offered by an accused or by the prosecutor reflects the same, or evidence of character trait of equalness of the alleged victim offered by the prosecution in a homicide case will let evidence of the alleged victim was the first aggressor. So that's kind of what governs that. It's already been kind of followed that. Of course, 412 is the great shield law, which is not being set into the talking about. So I recognize there are times that evidence of a particular character trait is proper. It could be one that do something into that extent. We have a different situation here too. Just to note that officers are authorized to use the force necessary to be able to apprehend a particular felon, and they're authorized to use deadly force under certain circumstances there, particularly if in fact there is a belief. I don't have the exact word in front of me. They have that belief that the defendant is likely to go ahead and cause great harm as opposed to such great threat or whatever to the other folks in the community. We're preparing a charge of that. We would be part of that charge we would offer. But it's a different situation than someone who is a victim who is you have a victim and also you have somebody who had committed the acts that were basically set forth at that time, as far as kidnapping someone, someone got out of the car, all that kind of stuff. I mean, you have that kind of matter, the situation that you're at that point is totally different, of course. And your act of Officer Howard reaching out to him would not constitute any sort of evidence like that. Now, he indicated, I changed what I had to say. He's alluded to here that Officer Howard says, I'm going to shoot you. There's no evidence of that. In fact, what we heard yesterday in the statement that was played, the whole statement, of course, at the very beginning, it said, whatever I get, I deserve. I can't blame nobody. And he made a number of statements like that. But at no time in that whole statement, the whole time he was talking, did he ever say, Officer Howard basically said, I'll shoot you. His statement, and somehow my statement hasn't changed. And I think you'll find that before there many times it's changed. We begin to elaborate a whole lot more. Specifically, his argument, the cases he cited here, don't at all say anything about putting in evidence that he wants to put in about any conduct of Officer Howard in regard to his current wife. So that doesn't have anything to do with that whatsoever. So other than that, Judge, I think it's clearly that matter, particularly, is not relevant. And particularly, though, when you start talking about bringing forward evidence of a particular character, there's a way to do that. And proper way to do that. I think it's this process where we get back to choose to do that. Whether or not that's proper, that may be subject to further emotion coming in part of that. We're talking particularly about the evidence as far as the conduct of Howard with folks who
time to open out.
That's why I said,
Yeah.
it never ends if we don't do this. So, that's why I'm calling for your attention.
Okay.
So I won't hear any more on that.
Okay, but can I say something other than, I mean,
Is there some other issue?
Yeah, some other issue. Well, I'm not saying this on you to make your ruling on that, but I would say I would like to stand corrected that as far as me, yeah, I guess the way he just put it, I said, my story never changed. But this, I'm not asking on that. This is a different issue. Please hear me.
Well, tell me what the issue is. Before you start, tell me what the issue is.
The issue is this. Hey, on credibility, I think he getting on credibility. Credibility this here. I think I might have been misstated when he said, hey, the story never changed, because I didn't tell everything. So as for credibility, yeah, I guess I misstated it.
I don't need to hear any more.
Okay, so, but they do go to credibility, right?
I don't need to hear any more.
Okay.
Thank you. All right.
That's something I want to announce the record. Yes, we obtained the personnel record of Chris Robinson. His named witnesses here. Is that right or not? We were able to obtain that yesterday. We're serving that this time, whether we use that or not. I'll get to make sure he had that to appropriate certificate of service.
Is that this copy?
Yes, sir.
I just like to object for the record. I mean, again, he knew Mr. Robinson on my witness list. I want to object because it's a 17-16-1, 17-16-4 reciprocal discovery. He's supposed to have it all in before we close discovery. And here again, we almost get him. He almost get him to the case. He's still coming here with more discovery. So I'm going to object because he violated the reciprocal discovery rule. He had Mr. Robinson on. He knew about that list. He was on my list way before we got to this point. So he said he just got this yesterday. He got 4 people he got a full staff. He's supposed to be here. So I was objecting him even bringing this into evidence because it violated the reciprocal discovery rule.
All right.
Thank you.
Well, I'll let you all know when we have more information.
Thank you.